When Professor Hoffman and I first started talking about what the title of this should be, besides the fact that it needed to be somewhat sexy to get people to be interested in attending, we talked a little bit about what has anything, about the question as to whether anything has actually changed in Washington as a result of the involvement of citizens on the internet in SOPA and PIPA. And like most things, I think the answer is yes and no. Grassroots as a tool in Washington is nothing new. I think the question is not whether or not the strategy of harnessing grassroots has changed, but whether or not the magnitude, because of the viral nature of the internet, and then the ownership of an issue by the public has changed. The origin of the involvement of the internet citizenry is the same as the origin based on any Washington fight on any issue that you can imagine. It wasn't accidental or unstrategized that all of a sudden certain blogs with certain positions giving a certain spin on these bills sort of appeared. That was part of a traditional campaign that was funded from, you know, big tech on one side, big content on the other, if you want to be that brutal about it, where people go out and give lots of money to third-party organizations, including bloggers and institutes, and people give their opinions, and the opinions get out. I think the question that's come from this is, how has it gotten out? Does it take on a life of its own? How does it connect with people? And how does indirect grassroots strategy turn into direct lobbying? I think that's the more interesting question. And I think it takes a couple of quotients that are important in order to harness the type of reaction that occurred in this case. The first is that in order to galvanize the public, you have to find a way of expressing your opinion that stops what would otherwise be a splintered group and unites them around one common cause. And that has to be something that is legitimate enough to be able to push. So while free stuff may be a fairly galvanizing point, that's not exactly the one that you're going to use if you're trying to get your spin out there in a way that's going to get people to own something and come back to Congress with it. But internet freedom is something that we can all agree with. And so regardless of the nuances and regardless of sometimes what the bill say or don't say, finding a theme that galvanizes people, that unites them, that results in ownership with direct contact back to Congress was a very important piece of this campaign. I do think some of the more interesting things that are going to occur because of the reactions to SOPA and PIPA have to do with some congressional process. And whether or not this becomes the new norm, I think depends on whether or not you can keep finding those galvanizing themes on issues that unite people enough and matter enough to them in their personal lives to make it work. But I think, for example, how you draft a bill is a consideration that members of Congress have to take into consideration moving forward, given what happened. I'll just give you an example. You know, this bill, PIPA and SOPA, were written by lawyers who write, you know, the Office of Legislative Counsel in the House and the Senate, write in a way that a judge would look at the bill and interpret it. So when they're writing the bill, they say, you know, a party has a right to bring an action before a federal judge under this standard, under Federal Rule of Civil Procedure 65. Now the public is not going to know what Federal Rule of Civil Procedure 65 says. One of the talking points against the bill is there's no due process. Well, I read the bill. I don't see any due process. There was a number in it, but I scanned over. How in the world do I know what that number means? Well, of course, if you know what the Federal Rule of Civil Procedure 65 is, you know that it is the gold standard of due process. You know that it requires a temporary restraining order after a showing of irreparable harm and immediate harm. You know that it only allows a 14-day temporary restraining order, that you have to come back for a preliminary injunction where you have to show a likelihood of success on the merits, and then that only lasts as long as the judge says based on the reaction of the defendant after some sort of effort to get an adversarial process, and then finally a third time for any kind of permanent injunction. Well, does that mean now that as bills go out for public examination, which is a good thing, that it's now necessary to make sure that you draft bills in such a way that people can recognize all of the process in the bill? Does it mean you have to repeat all of the provisions? The standards in this bill came word for word from the anti-circumvention provisions of the Digital Millennium Copyright Act and from a patent case that just came down from the Supreme Court on willful blindness, the Global Tech case. They purposefully went word for word because they wanted to incorporate all the case law, all the facts, so that when a judge was looking at it, it would be limited to the circumstances and bring in all the precedent that came with it. But if you're just reading that language in the bill, you don't know that it came from those cases. You don't know it came from that statute. You don't know it involves those precedents. You're thinking, this is the most vague, ambiguous thing I've ever read. And of course, if you're in a campaign in order to exploit that fact and unite people around it, it can be pretty convincing. So I think it may have ramifications for hearing processes, for the drafting of legislation. But I wouldn't say that it's bad or good. I would say that getting people more involved in the democratic process is good and helpful. Understanding that there are still sort of the foundations that we are a republic, and that the idea is for members to be able to, represent and understand at a level of study that sometimes is not available to the public. So, has K Street changed? No. Will campaigns change? No. Will grassroots change? No. But has the involvement of internet citizenry made a difference in how people will operate going forward in trying to harness this? Yes. And the last thing I'll say is that I also think that some things have been unleashed that get beyond the control of anybody who might be orchestrating this kind of grassroots involvement. While nobody who orchestrated this is responsible for Anonymous or what Anonymous does, Anonymous has certainly used this in a manner to cause a great deal of harm to a great number of people by jumping on the bandwagon. And was that foreseeable? Was it not? Is that just a side effect that's uncontrollable? Is it not? Those are cybersecurity questions that come up in an issue that was largely unrelated to cybersecurity. In my view, sort of made to be very related to cybersecurity for a lot of political reasons. But these are really interesting questions going forward, and I think we'll be talking about them for a long time.